Well, good morning, everyone. I'm joined by Chris Deacon, who you all know, I'm sure, from Stewarts Law and be familiar to you from APL and PIOPA and all of those acronyms. If you haven't joined us on one of our webinars previously, the webinar is being recorded and it will be, the link will be provided to you afterwards along with the slides. It will also be available on our YouTube channel. As a result of that, if you ask us questions, you identify yourself, we will identify you publicly. You may therefore choose to ask us questions anonymized, which is a thing that you can do. If you do want to ask us questions, ask us on the Q&A. You may want to chat to your friends on the chat, absolutely no problem at all. Feel free to do that, chat to us, chat to everyone else who's coming. But if you ask us questions on the chat, we may miss them. So it's probably better to put them on the Q&A. If you raise your hand, I have no idea what to do to action that. So that doesn't give rise to any response at all from me. So if you want to ask something or make a comment, then feel free to use the Q&A. If you have been to our webinars before, you'll know they're pretty friendly, pretty interactive. And we envisage this one as being particularly interactive because what we're doing today is sharing knowledge effectively. I actually don't know the answer of how to get the most out of your barrister. Chris has got lots of ideas on how to get the most out of your barrister, how to squeeze every last drop of blood out of us. So he's probably the more useful person to ask about this. But I think we all have something that we want to say about this, whether we're, I know we've got some barristers here today, whether we're solicitors or barristers, we all have war stories to tell, anecdotes, things that we feel will get more out of our barrister, because what we're trying to do today and what we're looking at today is working collaboratively, working as a team. So it's not really, I suppose the title of this webinar is not really how to get the most out of your barrister, it's how to get most out of your legal team, solicitors, barristers, legal execs, paralegals, and how to get the most out of the clients at the end of it all, which is what we're all trying to do together. So it's a collaborative effort. And in the spirit of that, feel free to interrupt whenever you like, ask us questions whenever you like, make just comments, whatever you want to say. If you disagree with something we're going to say, not everything we're going to say is uncontroversial. So feel free to say if you don't agree with something, and it would be quite good to get a discussion going. So in what we usually do with webinars is that we divide up the webinars. So somebody gives the first bit and somebody gives the second bit. We're not going to do that today because Chris and I thought that it might be helpful to have a discussion. He and I and you all discussing this topic, which we thought might be of interest. It's actually quite surprising to us that nobody teaches you this stuff. So I don't see that solicitors are being taught how to instruct counsel. And that's quite interesting because it's actually quite a big part of a solicitor's job to instruct counsel. So we thought it might be helpful to concentrate a little bit on the soft skills that we want to talk about today. One of the things that came up when I was talking to other barristers in chambers about this was that there was some conversation about what solicitors expect from barristers. So we made a list of things you should feel entitled to expect from us. And if you're not getting these things from us, then you should be, and you are entitled to ask for them. Obviously, knowledge of the relevant area of law, obviously these basic skills as a barrister, ability and willingness to actually read the evidence. And Chris, you were talking about this, about barristers who don't actually read the stuff you send them. I find this hard to believe.
Yeah, I think, do you know what, when you send a significant bundle of documents and evidence, and there may be a limited time in which counsel has to prepare, I think if they're honest about the fact that they may not have read everything, then the chances are you can help plug the gaps. But it's when they sit there and pretend that they have read everything and it becomes quite apparent during the course of the con that they haven't. So I did list that on one of, we were asked in advance about pet hates, and you'll see those towards the end of the session. We have a slide on our kind of bugbears, and that was one of mine. So, you know, I think perhaps it's the exception, but I've seen it often enough for it to grate on me, I suppose.
Yeah, I mean, really, if you're sending us stuff, we really should be reading it. So I think that's it's so basic. It really is. I mean, the corollary of that is don't send us stuff you don't want us to read. So sometimes solicitors will send through 3 bundles of medical records and they'll say, don't read them. And I actually find that quite difficult, because if you sent them to me, I should be reading them. If you tell me not to read them, why have you sent them to me? So I think sometimes there is an excuse for not reading all the papers, but only when we're told not to, or when we're told, well, can you limit your fee to 3 hours work? Because after 3 hours work, I'm going to clock off.
Yeah.
Not that I ever do, but I have a right to. The next one is another one of your bugbears, Christopher. I feel like we're gonna encounter a lot of bugbears as we go through.
This is like a therapy session for me.
English. Yeah, no. This is something that came up quite a lot, actually, the ability to communicate in plain English. I don't know whether barristers are going around communicating in Latin all the time, but this is quite a big deal for lay clients as well.
Yeah, I think, I mean, you don't see so much Latin nowadays, I don't think. But yeah, I think it is more for lay clients, actually. And, I mentioned that one of my particular bugbears is barristers that just speak in metaphors and similes. And you're sat there trying to actually decipher, what they're trying to say. I mean, they've obviously got their place. That sort of illustrative language, can be quite powerful, particularly in advocacy. But when they're in con advising a lay client, I think, talk particularly, and I see this because my practice is very international. With clients who don't have English as a first language, and the barrister's talking in some metaphor, which just doesn't, even if you had a translator in the room, they wouldn't be able to interpret it.
Yes.
So, I think a plea for plain English.
Yeah, and I think you've got a right to, if the barrister's not communicating in plain English, you've got a right to say, actually, this is not working for the lay client. You're not communicating with the lay client, and communicating is actually our job. So, you do have a right to call people up about that. Professional respect and courtesy was another thing that came up, and this feeds into other things we're going to say later on. What happens when you don't agree with your solicitor? And I've been led by people who have humiliated their solicitor in front of the lay client. You have a right to respect that, to expect that not to happen. You've got a right to expect your barrister not to do that. Yeah,
I've actually, this, I can give my perspective. I've taken soundings from my colleagues, as you have, Sarah, in advance of today. And there was one particular example, and I think, many will have seen this throughout their careers, where this particular colleague was actually leading the case. It was a high-risk case. They were preparing for trial, and she was left feeling really quite disrespected because counsel came into the pre-trial con and the supervising partner was in the room because of it being a high-risk case, because it was so close to trial. And the barrister went round the room asking if anyone had anything else to say, and completely overlooked the lead fee earner on the case, who had actually instructed counsel. She actually felt in a very awkward position, had to put herself, make her voice known and really put herself out there. And the result of all of that is that barrister just won't get instructed again by that solicitor. And it's incredibly short-sighted, because actually this was not a junior colleague of mine at all. But even if it was, actually that junior colleague will one day be in a position where they may be instructing that. They may be calling the shots. They may be the supervising partner on that case. So I think it goes to professional respect and courtesy, but also collaborative working. And, the cases that I deal with, they're big cases. It takes a huge team to get them to a successful conclusion. And that goes right through from the paralegal to the supervising partner and everyone in between.
For sure. I mean, I was a paralegal briefly before I came to the bar, and we went to a con with a silk who, we walked through the door into the con. It was me, the supervising partner, and the lay client, who was a business owner. And I got on quite well with the lay client, actually, because I liaised with him a lot as the paralegal on the thing. We went into the conference room, and the silk was sitting there. And as we all sat down, he said, "Oh, everyone would like coffee." And then he just pointed at me and went, "You can do that." I was like, I don't know if it's because I'm female. I don't know if it's because I'm a paralegal. I don't like it. And actually the lay client said, "No, she can't. You're hosting. You pour." It was like, oh, okay.
Absolutely.
But I think there is a professional courtesy between the branches. And you're right, collaborative working is really important, because although, you know, often you're coming to us for advice, you've got your own views about it. And making those known to us is really helpful to us. So I think collaborative working, to turn it around a little bit, is something that can only happen if you tell us what you think. So don't just sit there thinking, you know, this is all, you know, not what I wanted, not what I expected. You've got every right to say, actually, I expected this from you, and I think this about the case.
Yeah.
That's not wrong.
Yeah, no, I agree.
Another thing from the barristers that we were talking about in chambers is willingness to listen and involve the lay and professional client. And that goes with collaborative working. But I think sometimes you get barristers who are quite overbearing with the lay clients and can be quite, well, this is how it's going to be. Yeah. And actually, it's the lay client who's in charge here. The lay client is the most important person in the room.
Yeah. One of my colleagues had...
that.
Yeah, absolutely. I mean, one of my colleagues had a particularly bad experience on this point, and, you know, counsel failing to show empathy to the client, despite having been instructed to do so. You know, they've been given some pointers that the client was perhaps a bit uncomfortable, but counsel was just constantly focused on the negative aspects of the claim, saying, you won't recover this, you won't recover that. And, you know, the client found it really quite difficult. Instructing the solicitor asked counsel to bear it in mind, and they completely failed to do so. You know, the client is then thinking, well, is this the right barrister for me? You know, and
what can you do about that, Chris? So I mean, instructing them, that ought to be enough. If you're having the con and the client's feeling like that, you know the client's feeling like that, what do? Do you stop the con and say, okay, you know, I think actually the client is feeling like this. Yeah. Could you address your mind to that?
Yeah, I think, you know, that's how I would deal with it. I would probably, you know, make it clear that a different approach was needed, and, you know, because I think sometimes the client can feel sat there and feel like you need to support them to have a voice as the solicitor in the room. So yeah, I think that's how I would deal with that. I mean, ultimately, if it persisted, and that seemed to be the case in my colleague's experience, then you may need to look at changing counsel, unfortunately.
Yeah, that's something that we don't really do very often. You don't see a change of horses halfway through. There are downsides to it. But if you're not getting this list of kind of shopping list of bullet points, you need to think about changing your barrister, because you're not getting what you should be getting from them. And the other thing that you've got to get from them is an ability to take your own decisions. That is what we're here for. And if you've got a barrister who dithers about things, who won't take decisions, who deflects decisions back onto you, that's something that shouldn't be happening. So you need to think about changing your barrister in those circumstances, because if they're dithering about things with you, they're going to be dithering about things with the judge as well. And it's hopeless. From an anonymous attendee, I think the final point about taking your own decisions is really important. At times it can appear as though some barristers are sitting on the fence with advice rather than being clear about what the advice actually is. Yeah, I mean, if you're coming to a barrister for advice, what you want is a decision. You don't want here a range of things that might happen, and I can't tell you what it's going to be. I have to say, occasionally I sit on the fence about things. I try not to, because otherwise our advice is not worth anything, is it?
No.
So I think decisiveness is really, really important in this context.
Yeah, I mean, it's what the solicitor wants. It's also what the client wants.
Yeah. And you're entitled to ask for it. If you're not getting an answer from your barrister, you are entitled to press them for it. I've got a friend who went through a divorce, and he went to see this very expensive silk, who said, oh, this is a really difficult legal question, and here are all the pros and cons legally. It's a very interesting legal question, all the pros and cons, and I can't tell you what's going to happen. And my friend was like, I'm actually spending money on this. I was very dissatisfied, is still very dissatisfied with that, and very dissatisfied with his solicitor as well, somewhat unfairly, because he didn't get an answer. And actually what should have happened in that con was that the solicitor should have said, actually, can I stop you there? The lay client doesn't care how interesting this is. The lay client doesn't care what the legal cases are going back and forth. The only thing the lay client wants to know is, am I going to win or not? And if your barrister's not giving you that kind of, I think you've got a 60% chance of success, I think you've got a 70% chance of success, I think you've got very good chances of success, then you're not getting what you've got a right to expect.
Yeah.
So I think that is really key.
Mm.
So with all of that in mind, you'll want to be choosing your barrister. I know, Chris, that you've got views on tailoring choice of barrister to the particular case.
Yeah, well, I mean, first and foremost, your client. I think you have to think of your client, and they're all different, and so just going to the same barrister who you like and you can work with may not necessarily be the right thing for that particular client. And share your thoughts on choice of counsel with the client, so that they actually have a chance to have a say before you approach the barrister and instruct them, and you've got them on board with that choice. I think that's really important. You will know the client well as the instructing solicitor by the time you come to choose counsel, and so I think you ought to have a good grasp on who is the right personality fit for your client. Also, who's got the skills and expertise for the job, and that may require you to have different counsel for different issues in the case. It's a point we'll come back to, but a sort of issue-based approach to instructing counsel, I think it's important. Not just sticking with the counsel who might be right for your private international law issue or your liability dispute. Once you get into what is actually then quite a heavyweight quantum side of the case, once those issues are resolved, don't be afraid to switch out to get the very best for your client, but also you'll be getting the best out of counsel as well in adopting that approach, I think. The personalities point is interesting. I've done some cases in the US, and there was far more emphasis on the personalities in the room. In fact, at a mediation in the US, that seemed to take over the discussions. Rather than it being about the legal issues, it was all about so-and-so in the other room and how what they are, what they're like, what a pain in the backside they are, or the mediator as well was in on all of this gossip about the different lawyers' personalities. I think we see that less so over here, but I think it's definitely something to bear in mind. And also the other side, who's on the other side, what's their game plan likely to be, and how does that influence who you choose to instruct?
Yeah, for sure. For sure, I agree with that. And then there's these various tools that we can use, aren't there? The looking in the directories, and often lay clients will do that. They'll check in the directories. If you're recommending someone, you can say, well, I'm recommending this barrister and they're in the Legal 500 or whatever it is they may be in. And again, the other tools that we're looking at there, webinars and tools can tell you how they communicate. There's nothing better, I think, than a recommendation from a colleague, from someone you trust internally. You can't trust clerks, everyone knows that, but they can tell you that depending on the relationship you have with the clerk, they will tell you who is best for this particular job. And actually, sometimes I'm asked to give some input on who would be best for dealing with an aspect of the case. And this comes back to your issues-based approach. And I've actually got one at the moment where it's a really difficult quantum case. Thank God I'm not doing that part, but I'm doing the private international law part, because it's too difficult. It's difficult in two different ways. So they've got two different barristers of roughly equivalent core, which is, you don't see it very often actually. Rather than someone very senior, someone very junior, they've got two kind of senior juniors. And I think actually that in many ways, that's a better way of dealing with it, because they've got two people who are equally competent dealing with the different aspects. So I quite like that, and I'm quite enjoying it actually. It's quite, the barristers derive a lot of benefit from bouncing ideas off each other as well. So I think that really helps. I think it's a good idea for it, for what it's worth.
I can see that being a good dynamic actually.
Yeah, it is. Barristers hate beauty parades. We've said on the slide, all barristers love beauty parades. It's the thing I hate most in the world, because you're just going along to see the lay clients and to try and impress them. That's not a thing that we do very often. Quite often at beauty parades, I crash out because I tend to say, well, what exactly do you want me for? Okay, you want me to do this? No, I wouldn't be as good as this other person. So beauty parades are disastrous for me. But I think actually, if you have a beauty parade, if you've got a particular lay client, you might want to have a beauty parade of barristers. But if you do, and the barristers who are coming along to it and not suggesting other barristers, then just think about that, because you know, we all know who the most suitable people are, so we can help you with that. Silk versus Junior, Christopher.
Yeah, I think it's kind of an age-old dilemma in some respects with certain cases. Obviously, it doesn't apply to every case, but yeah, which do you go to? I think, you know, it goes back to the collaborative working. It doesn't matter how senior the barrister is. You want them to be an integral part of the legal team and to be prepared to work collaboratively. I think, you know, it cuts both ways. You might have a junior who then realizes, or you realize, that there needs to be a silk brought on, and also the other way around, when you've instructed a silk and you realize that you or they would benefit from a junior. One of my colleagues, on the first point where they had junior counsel, one of my colleagues recently had an experience where the defense came in and that had been drafted by a silk on the other side. And the way they had junior counsel on the case, and they then kind of appreciated the issues that the defence were going to run, and decided that they probably did need a silk on their side as well as the junior barrister. But the way they dealt with that was to actually involve junior counsel in the decision-making process. Yeah. So junior counsel, you know, who do you think you would work well with? They suggested someone in their chambers who they'd worked with before. And it worked out really well. And actually the case settled for about twice what we, you know, when my colleague kind of opened the case, gave an estimate of likely damages, they you know, the QC really added value in that case. So I thought that was a good example of how to address that. With a silk, I would
always ask a junior to recommend a silk. When I was junior and I had silks imposed on me, I hated it.
Yeah.
And actually it made us all work less well than we would have done otherwise, because we just didn't work well together.
Yeah. I think with, you know, with a silk, you know, when do they want to have a junior involved? For me, I think the volume of evidence can be a driver there. You know, if there is a lot of evidence that they've got to get through in con, or as you kind of edge towards trial, then that seems to be an indicator for a junior. Also, you know, if there's a particular issue, you mentioned your case where you've been brought in to deal with the private international law issues, and I think that's a really obvious example of where you might want a junior to come in. I've got a case at the moment where we have leading and junior counsel, but actually there's a point of EU law that's arisen, retained EU law, should I say. So we've brought in another senior junior to deal with that very specific issue.
Yeah, I think it can work well. A question to share: when to charge counsel as a disbursement, when to absorb counsel's fee within our own solicitor's fees, the latter sometimes an easier sell to the client. So well, I think it depends on the client, actually, and it depends on the case as well. I know that's not very helpful, but I think you can charge us as disbursements if there is a particular thing you want us to do, so a particular advice at a particular stage, or obviously hearings at a particular stage. But otherwise, I think it all gets subsumed within your own fees. If you're asking us to do things like check over correspondence and stuff like that, clients are just not going to stand for that. So I think is there a particular reason why you're instructing counsel, I think?
Yeah, I mean, we would have counsel's fee note kind of sits separately to disbursements, I suppose, because of the funding arrangement. In the work that I do, counsel would usually be on a CFA as well. So it's not treated as a disbursement in the sense that a medical expert report might be, for example.
Yeah, I mean, it's different. It depends whether you're working for claimants or defendants, doesn't it, and how you're working. Engaging with direct access barrister. I don't actually do direct access work, and I don't think Chris engages with them very much either, so I'm not sure we've got a huge amount of value to add here. But what I've been told by the people who do direct access work is that they want you to provide more information rather than less, but in a logical order. And I think actually that most barristers would echo that. If in doubt, give us the documents and we'll decide whether we need to read them or not. but tell us that you're giving us the option of reading them or not. Put them in order and give us a summary that tells us what the case is about, and as if you were instructing. We'll come on to that in a minute. And direct access barristers, so I am told by direct access barristers, tend to be more able to deal with logistics, so court logistics, as opposed to us. We have to rely on our clerks to do it, or on you to do it. When to instruct, we've got various tensions here, and we'll just whip through them quite quickly. If you instruct early, you can shape the case together, you can collaborate earlier. And as Chris points out, you can conflict your barrister out. So if we work in quite a niche area in sort of cross-border stuff, if you want to conflict somebody out, instruct them early. We love that. It's our favourite thing in the world, being instructed early and conflicted out. But it does work. It does work, to be fair.
Yeah, and it's just a question of a short email, actually, with enough detail that they can't accept instructions from the other side.
Yeah, I really don't like this, but yeah, you're right. And as you go through, the later you instruct us, the less value you get from us, because the less we're able to help you to shape the case. And Chris's example of getting twice as much money as they would otherwise have got, it's quite a good one, and a good reason as to why you should instruct us as early as possible. And I realised that I would say that, wouldn't I? But actually, it is good advice to get your barrister involved earlier rather than later, because we may have, two pairs of eyes better than one, right? We may have ideas as to how to maximise the case. And actually, there's nothing more frustrating than being instructed at a very late stage, so instructing at trial, and having to run a case that's been run not the way you would run it. So I would make a plea for instructing us sooner rather than later, not just because that's in my interest, but also because it's in the client's interest, actually, because it gives us an opportunity to help more.
Yeah, and I've got friendly barristers, Sarah is amongst them, who before we've perhaps even been retained, we'll be looking at the issues in the case, and I might ping a query across to counsel to see what their thoughts are. I think you have to be mindful, if you're doing that you might then honour that barrister with the instruction in the case further down the line. But that's obviously subject to the various other caveats that we've been discussing.
Well, it's a relationship of trust, isn't it? I know that if you email me about a case, that if it does get taken further, that I'll end up doing it. So it's an investment of my time to help with a case that I will end up doing. If I get a lot of queries, and I do get lots of queries from particular solicitors, there comes a point where you're like, actually, most of what I'm doing for you is for free. And that just slightly feels like a breach of professional courtesy, actually. But as a matter of courtesy, with people who ask nicely and people who instruct me, I'm very happy to answer any queries they may have, as you all know, because we all give each other queries. But yeah, I think first of all, you've got to trust your solicitor that the brief's going to come your way, and secondly, you sometimes get queries that are couched unfortunate language. Counsel will consider. Counsel is required to consider. You're not paying me for this, a please doesn't go amiss, actually. It's really, really basic stuff, this, but you would be surprised. And how far in advance? This is part of when do you instruct your barrister. I know there's a tension here as well. If you instruct us too far in advance, you might incur a brief fee or be an abated one. If you instruct us very close to the hearing, we've got no ability to maximise your chances of success in that hearing. And a little plea from other people, not me, I have no personal life, other people in chambers. What we really don't like having is very, very large quantities of documents delivered to us on a Friday afternoon with an email that signs off, have a lovely weekend, because we're not going to have a lovely weekend. And I've actually, an anecdote from a friend of mine who was regularly instructed by a particular firm, but the firm would send over a black cab from their offices full of boxes. And he had a window out onto the road outside where the black cab would stop and unload the boxes into the clerk's room. And he said that he used to dread Friday afternoons because it was as if that particular firm would wait till the Friday afternoon and then go, what can I do to clear my desk on Friday afternoon, I'll just send everything on it down to this particular barrister and I'll ask him to advise or do things by Monday morning. There's a lot of goodwill here, but you're slightly eroding it doing that. But, you know, sometimes it's absolutely inevitable that you're going to do it to us. And I have to say, for some reason, the late August bank holiday is a bank holiday that I have never, ever, in my entire time I've been at the bar, spent not doing papers. For one reason or another. And you know, it is inevitable and that's fine. But just an acknowledgement, I'm really sorry I'm sending you these now. The reason for it is that the other side have only just disclosed it, or there's a hearing that's an emergency, or I'm really sorry, I just forgot to send it down, or I'm so sorry I've ruined your weekend. And I'm fine. A huge cab's worth of papers saying, do this for Monday morning. I'm not so fine. And, you know, and you may be thinking, well, so what? As long as you do it, which I will, what does it matter? It just means that next time your query goes to the back of the queue rather than the front of the queue. And just a little bit of courtesy sometimes and a little bit of an acknowledgement that we are doing things out of hours goes a really, really long way. Instructions. Now did we have a question on instructions? Yeah, so when instructing counsel to draft pleadings or advise, what are the most common omissions that hinder or frustrate providing a response? So if you're asking us to do something, what do we need? Well, okay, comes in two parts, instructions and the brief. So there's continuing on instructions. You either put a post-it note on a box of papers that says, please deal, which I used to have a lot from someone who instructed me very regularly. And he was the most charming man in the world. And he would ring me up and he'd say, I've sent a box of files down to you. I don't know what to do. I've reached a point in the case where I've just got no idea what I'm doing. And he'd stick a post-it note on and go, please deal. And I'd be like, absolutely fine. I'll express myself freely. Otherwise, the other end of the spectrum is a very long document that contains quotations from all the other documents. That actually is not enormously helpful. What is the absolute tip-top thing that you can do for us on instructions is to give us a description of the facts, a description of the procedural history, and this is where we are, and then this is what I think about the case. And actually I have to say, Chris, you are really good at that. These are the facts. I know you don't remember this case. It's you last saw it 6 months ago. It's amazing how often you get instructions that say, counsel will remember this case well. No, it's not just me. Counsel does not remember the case well because we do so many different cases. And if I last saw it 6 months ago, there is not a prayer I remember it. But telling me where I am, so we're just about to have a CCMC, or we've just had a CCMC, or the expert evidence is now in, can you please advise, is really helpful. And another plea that came from other members of chambers is, tell us what you think of the case. And Chris's point on that is try to be objective. Don't assume that we'll agree with you.
No, I think that's right. I mean, you want an independent view from counsel, so I think you have to, certainly express your take on things, but try and remain reasonably objective if you can, because you don't want to lead counsel if ever that were possible. You don't want to lead counsel to a particular conclusion. Now, I know with Sarah that's never possible, but yeah, I think it's just something to be mindful of when pitching your instructions. I mean, you mentioned the structure of the instructions to counsel. My typical structure is to have all of the enclosures at the start in a decent order, and I should say something about bundles in relation to enclosures. We're e-bundling everything to counsel now. That even those that were very reluctant to receive papers electronically have been forced to do so over the last 18 months or so. And I think, when you're putting those bundles together, it will take several hours, but you'll get much more out of counsel in return if you prepare that as if you're preparing a bundle for a hearing at court, with bookmarks, etc., and everything hyperlinked. Then I'll address the funding issues in the case and make it clear that counsel is being asked, certainly in my line of work, to act on a CFA, provide basic details on the claimant, and I think it's important there, if they don't have capacity, for example, that you outline who the litigation friend is, because that's who will be providing instructions in any future with counsel. As Sarah said, background details, circumstances giving rise to the claim and action would be the next section. Then procedural history, then key evidence, expert evidence, witness statements, not quoting from that evidence, as Sarah said, because you will have enclosed it for counsel to consider and form their own view, but just highlighting the key aspects, any particular issues in the case, and then the instructions and brief to counsel, being clear at that point, I think, on what it is you want counsel to deal with. Because then you'll get the answer back from counsel that you're looking for.
I think also what's really helpful is that if you've got something that's urgent, or at least needs doing in the next couple of weeks, in the covering letter or at the top of the instructions, it's really helpful if you tell us that. And it's helpful if you tell us that in the covering letter, because then the clerks can see it and they diarise it for us. And if you tell us at the beginning of the instructions, we can see it and we diarise it. Because occasionally you get instructions that it's an emailed instruction that says, here's a bunch of papers and some instructions, can you advise? And I think, yeah, fine, I'll do that in a couple of weeks' time, because I've got a couple of weeks' work, I've got a lead time. And actually, a day later, you might get rung up and people say, well, I need it tomorrow. I kind of think, well, I really wish that you'd mentioned that, because I triage everything. Not everyone does triage everything. But even when I'm triaging, it's quite easy to miss a timescale if you haven't put it sort of in red ink across the top or in the covering letter. So I think that's really, really helpful. Now, in relation to what comes with the instructions, what do we want? Somebody asked how many electronic briefs we're getting. The vast majority now are coming through electronically. I can't remember the last time I had a paper brief to advise, although I occasionally get paper trial bundles. Please don't send us emails with 58 attachments. One of the things that came up in chambers was that if you send an email that says, can I have your advice? And you send a very large number of attachments to that email, first of all, we can't be sure we've read them all. We might have missed one or two because we can't be sure we've opened them all in order. Secondly, sometimes we can't find the instructions. So sometimes you'll get an email with a very large number of attachments and the instructions might be attachment 28. It may also not be called instructions. So you sometimes get emails that have attachments that are just, they don't have headings, so I don't know what they are till I open them. If the attachments are just numbered and I don't know what they are, I'm opening them in a random order, looking for something that helps me determine what it is you want and when you need it. So my own preference is by far and away for hyperlinked e-bundles. Some people who use document management prefer emails with attachments, but if you're going to do that, sending lots of attachments is really dangerous, because we are going to miss one or two potentially, and that's how mistakes are made. And secondly, if it takes me half an hour to find the instructions, whisper it, but you are likely to go to the back of the queue, because a beautifully produced bundle that I can see what I need to do easily is just psychologically, I'm much more likely to put it to the front of the queue than I am a bundle that's all over the place because I can't find what I need. The other thing that you were asking about with what do we need, what are the things that hinder us doing what you want us to do? Photographs not being photocopied properly. Quite often get just blank sheets of paper, I don't know what it is. Can I advise on scarring without having seen the scar? No, I can't, I just can't. Advising on foreign law and standards, I can try. I'm not qualified. That's the problem. I'm not insured to advise you on foreign law. So if you ask me what the Turkish limitation period is, I know what it is, but I can't tell you because my insurer will go nuts. Advising on medical negligence in the absence of medical notes is really, really difficult. We can give you preliminary advice about those things. What we can't do is give you the advice that you're paying for about those things. On bundles, just being asked, do we prefer to have one document with bookmarks or separate electronic documents? I actually can't get on with bookmarks, but that's because I'm very ancient and I don't really get on with technology. Every barrister is different, and the gold standard would be to ask us, how do you want these instructions? I do think, though, that if you're going to send through something very big, my preference would either be for paper or an electronic hyperlink bundle. But certainly emails with lots of instructions are dangerous, I think.
Yeah.
Now, Chris, coming on to your area of expertise, which is GDPR.
Yeah.
We had a number of questions about GDPR before we started. And I knew the answers, obviously. I just didn't know why they were the answers, whereas Chris knows all about it.
Well, I wish that were the case, but I've consulted our in-house GDPR guru at Stewarts to provide some guidance on this. I think GDPR, I perhaps shouldn't say this, but I'm going to. I think it's one of those areas where everyone panics because they're used to it being used as an excuse for other entities not providing you with information that you want. But actually, when it comes to sharing client information, you'd usually have the client's consent anyway. But it won't be a breach of data protection because there are exemptions under the data protection regime which provide a lawful basis for processing of personal data, your client's personal data. So those are Article 6.1b of the GDPR and 6.1f, where processing is necessary for the performance of a contract to which the data subject is a party, or in order to take steps at the request of the data subject prior to entering into a contract. So that the contract would be your retainer with the client, pursuant to which you are instructing counsel to take steps in the litigation, or processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject, which require protection of personal data. And that's particularly relevant if the data subject is a child, for example. But that's a balancing exercise. Article 9 deals with special category data, which would, for example, include health data, which in a claim for personal injury damages is obviously going to be permeating the instructions. But Article 9 permits processing of that data where it's necessary for the establishment, exercise, or defence of legal claims, or whenever courts are acting in their judicial capacity. So you'll see that providing your client's personal data to the barrister is fine. It falls within the exemptions within GDPR. And the same goes for third-party information as well that you might hold and include in the instructions. So there needs to be a lawful basis for processing that third-party data, but it would fall within those exemptions within GDPR. Confidential information, that's different to personal data. You do have to be careful there because you need your client's express permission to share confidential information with third parties. Now, if you're pre-retainer and you're sharing information with counsel, you need to be very careful to make sure you've got the client's consent. Usually, if you've got a decently framed retainer in terms of business with the client, there will be express consent in there that the client signed up to sharing of confidential information. That's all I propose to say about GDPR, and I hope there aren't any further questions from the audience today on that.
Yeah, I'm just doing the query about instructing counsel for the same chambers. You should be fine to do that because we're all required to risk assess and have risk assessed GDPR. And we all have secure spaces where we keep our documents. So you should be fine with counsel in the same chambers in that regard. Cost budgeting, just quickly, because it's not my favourite, it's another one of my least favourite subjects. Do seek counsel's input when preparing the budget, because otherwise it may be unrealistic and you do not want to get to a point where you've put a certain figure in for trial and you just cannot get the counsel of your choice for that figure. And that is a sort of catastrophe event. So do ask for input on that, but I would tend to ask the clerks and they will then ask your barrister in respect of what they think is the appropriate fee in related to that. And then once you have budgeted, counsel needs to know they've got a certain amount, unless you're going to supplement with your costs, counsel needs to know that they've got a certain amount to play with. And actually it's important to be upfront about that now that we cost budget. There is a sort of feeling that we can't talk about fees. But tell them, you know, we've got however much money is in the pot for you. So how do you want to use it? Again, unless of course you're proposing to supplement us with your fees, which is very much what I would recommend you do. In relation to fees, as I say, fees are negotiated with clerks and not counsel. Certainly in my own set, any fee queries that we get, I just pass on to the clerks because they don't like me dealing with it myself. Always agree fees in advance if you can. I know that sometimes you can't, but that's something that should be happening because it prevents any nasty unpleasantness later. And in relation to that, request a fee quote before you do anything. I mean, even Chris and I, we've worked together for lots of years, decade. But I think you'd be inclined to ask for a fee quote in advance, just so you know what it is that you're signing up to. You know, you've got to give us some details of what are you dealing with, what do you want, how long do you think it's going to take, and then get a fee quote so that everyone knows, you know, I know how long I've got, you know what you're going to pay for it. So there's nothing wrong with doing that. When to pay, a thorny issue. A lot of claimant firms pay at the end of a matter, inevitably so because there are so many CFAs. What you will find that your barrister gets a tiny bit resentful about is where we negotiate or we ask the court for a gigantic interim payment on account of costs, and then we don't see any of it. And again, there's a continuum of that between those firms of solicitors who pay their barristers' fees out of payments on account of costs. So we get paid in full when we get the payment on account of costs. Those ones who pay the same proportion. So let's say we get 2/3 of our cost bill in a payment on account of costs. I get paid 2/3, you get paid 2/3. And those firms of solicitors who simply will not pay us anything out of an interim payment on account of costs. I have to tell you, there is a particular firm of solicitors that I work for quite a lot who will not pay us up front, even when they get interim payments on account of costs. It is not very motivating, actually. Not that I make any less effort for them than anyone else. They just don't go to the front of the queue all the time in the way that other people might, because it seems to me that that's actually rather unfair, because it means that we wait for our fees for 7-10 years when that solicitor's been paid sort of 5 years after starting, whatever it may be. So I think being upfront about it, you know, I'm in a safe space, and I'm just saying that I think that's the absolute gold standard, that we get paid out of the interim payments in full. You know, I mean, literally, I will walk over hot coals for those solicitors because they understand that we're self-employed, and they understand that it's quite nice for us to get paid. The ones that don't understand that and just take the opportunity to reduce their cash flow problems, you know, your barrister doesn't love you as much if that's what you're doing to them. Conversely, do not be afraid to ask for a reduction in counsel's fees. If you think that the brief fee should be abated for one reason or another, don't be afraid to say to the clerk, well, you know, they thought they were going to spend more time on it. We thought it was going to be a day-long hearing. It went off. Can we have a reduction in fees, please? And usually I think clerks are prepared to be reasonable about that, don't you, Chris?
Yeah, I certainly do. And, you know, your experience is the clerks will deal with that without referring it back to you. I suppose it depends on the issue. I think other sets, the query does end up back with the barrister. I had one particular case a few years back where the barrister sat in the pre-JSM con and then the JSM and was just bragging about how much work they had on at the time. The JSM actually ended up being very short. We reached a successful conclusion pretty swiftly. And I then looked at how many hours were being claimed in the brief fee. And I said, well, I know you haven't spent this time because you sat there telling me about all of the other work you had on. So that was quite easy to negotiate a significant fee reduction actually in that case. But I think that's kind of a benchmark. If you break down the brief fee against the hourly rate and see how many hours that translates to, is that reasonable? I think that can help with negotiating those fee reductions. And detailed assessment, if you have the misfortune of getting that far in the cost assessment process, then you know, I wouldn't hold back in asking counsel to justify their time as well. If you've got close to trial and brief fees have been incurred and then the case is settled, counsel may have to produce their diary to show whether they found alternative work or not, to see whether those brief fees stand up. And I have in the past got supporting notes and memos from counsel in relation to the time they've spent to help with the cost assessment process.
Yeah, and that's not unusual at all. It's in everyone's interest that we do that. Rather than asking you to justify us, just ask us. It takes another problem off your plate, and it's in our best interest to do it ourselves. So I couldn't agree with that more, actually. Now, on to conferences. This is something that we were asked about. When do you have conferences? You can only recover from the other side in relation to so many conferences. I think if you have a sensitive case, so for example, sexual assaults or deaths, if you're acting for the claimant, have an early conference, because they need to know who it is that's dealing with their case, and they need to trust that that person is sensitive. For that reason, in those cases, it's very important to choose the right barrister for a sensitive case. Conversely, if you're defending those sensitive cases, and we forget this, I think, witnesses and alleged tortfeasors in sensitive cases have just the same sensitivities as complainants do in those cases. So, for example, someone who's been accused of a sexual assault needs just as much sensitive handling as a person who is making the accusation about the sexual assault. For what it's worth, I think in those type of cases, in sexual assault cases, female, I'm not sure I'm allowed to say this, am I? But I think female counsel can be more appropriate in those cases, because often you will find that your lay client wants to talk to a particular type of person. But listen to the lay client. What kind of barrister do they want? I think consider having a conference with counsel and experts in more difficult cases. Anything that isn't run-of-the-mill, you really do want to have a conference with counsel and the experts, and relatively early on as well helps a lot. Pre-trial conferences obviously helps a lot, just to settle the clients, I think are worth doing. Consider doing it remotely, but not in relation to sensitive cases. You can't do that in a case where someone is very vulnerable, or if they have a particular need for witness handling. So that's when to have a conference. What to expect from a conference? Well, that's really up to you, but you need to let us know what you want from the conference. So what's the agenda? What issues do you want us to cover? Who do you want to lead the conference? Will you be in the driving seat, or will you hand over to us? As Chris has said previously, tell us if the client's got a particular sensitivity. And if we're not sensitive to that, stop us, haul us up and remind us. Give the lay client some idea of what to expect, because they need to know what's going on, where they're going to be, what type of building they're going to be in, what kind of person that they're going to be meeting. If counsel gives you homework before a con, do it, or if you can't do it, then just tell us, that's fine. But the thorniest of all these issues that we looked at when looking at this was what you do when you don't agree. So we've been talking a lot about collaborative working. What happens if you and your barrister disagree with each other? I had a case once where I was brought in to advise about something, and it was a very odd situation where a barrister had been instructed on behalf of a defendant. They were having a con and they wanted me to go in and advise them about a case that I had been involved in and what happened in that case. I got permission from my solicitor to do that, and I went in and I told them what had happened in the case. Then I expected to leave, but the lay client then started asking me questions about their case, and it became apparent quite early on that I didn't agree with the barrister they had actually instructed in that case about what they should do. So the lay client was left in this situation where they had two barristers telling them two different things. I mean, you should never be in that situation. Your lay client should never be in a position where there are two lawyers giving them diametrically opposed advice, and you want to avoid that at all costs. The way that I deal with that is that if I think Chris and I are going to disagree about something, I give him a ring and say, look, from your instructions, you've told me what you think about this. I'm not sure I agree with you, actually, and we'll talk it through and reach a point where there's a consensus, or alternatively, where I'm able to say to the client, look, there is a range of views here, and one of the views is this, and the other view is that. On balance, I think we're likely to do this, but there are risks. Yes. But that's one of the reasons why we need to know what you think, because what you don't want to end up with the situation is where I don't know what Chris thinks, so I'm telling the client something totally different to what he has already said to them. And that's just presentationally really poor.
Yeah. It's all about having a discussion before you go into the com, really, making
It
sure
really
you're, even if you're not on the same page, you know what the other person's position is.
Yeah, it really is. Do you want remote hearings? We prefer remote hearings as barristers because it enables us not to have to travel to Carlisle on a Friday. We really appreciate it if you therefore ask for hearings to be remote, if it is appropriate to have it remotely. It isn't, where you've got these issues of fundamental dishonesty. If you've got a heavy case, if you're, for example, you've got a trial, if you've got an agreed consent order, as I had actually during COVID, and I went to Birmingham for 5 minutes to present a consent order, the judge said, "Why are you here?" I said, "I don't know why I'm here." The judge will go away. And that was fine. I didn't sit down, it took 2 minutes. But actually, I would have much preferred my solicitor to make an attempt to get that heard remotely. And, you know, again, we'll really appreciate that. We owe you then. You know, then if you're raising queries with us, don't be embarrassed about emailing us with a query, because you've just done us the massive favour of not having to go to Birmingham. If you are going to do a remote hearing, remind the witnesses to dress and act appropriately. I can't believe I'm having to say this, but someone else in Chambers said that they had a witness who turned up, was smoking a cigarette, having a cup of coffee, and wearing a baseball cap. Judges are quite old-fashioned. They don't really like that. They much prefer it if the witness is dressed up a little bit. Pre-test hardware and software. Make sure that the client understands what they're going to be asked to do, and remind them to pre-read their witness statements, because we won't be doing that, because we won't be seeing them just before the trial. If you've got expert evidence or document-heavy cases, it's not going to be appropriate for remote hearings realistically. Now, in relation to ADR, Chris, I know that you have some strong views about this.
Yeah, I suppose it goes to, you know, how the dynamic of negotiations and how that is actually managed on the day. And certainly I like to be involved in the negotiations. I know many of my partners and colleagues at Stewarts do. So I think you need to make that clear to counsel. You know, they're not going off and doing negotiations on their own. You will be in the room as well. And it can be really helpful. You know, I know Sarah and I had a JSM recently where we adopted that approach, because that's my style. And it actually worked really well. You know, there were a few points that the defendant's barrister brought up that we were able to address there and then, because I had that particular knowledge of the case, and there was actually a dispute over something that had been said between the solicitors on either side, and I was able to kind of put that right. So I think, you know, just be clear as to the approach that you want to take when it comes to ADR. Don't leave all of the work to counsel as well. I think, you know, you know the case, you ought to prepare in, you know, a similar way to counsel for a settlement meeting. So do your own liability analysis, your own risk assessment of the issues, your own quantum analysis as well. It will help counsel, because they'll be able to advise the client that there are a range of views. And actually, you know, in one of my recent settlements that required court approval, counsel then referred to the valuations from leading counsel, referred to his valuation, junior counsel's valuation, and mine in the approval advice, and indeed at the High Court approval hearing. So you know, it's not wasted time. It's all valuable effort to securing the best results for your clients.
Yeah, it helps us so much. I mean, just so much. And not because it means that we don't do the work ourselves. So I don't look at the valuations before I prepare. I prepare for the JSM or whatever it is. And then I look at what your view is. And I think, oh, that's totally different. How interesting. Or alternatively, okay, we've come to the same conclusion, so we can be quite confident that we're probably right about that on what we know. I think it helps enormously, actually, with JSMs to have an idea. I had one solicitor who used to put it in a brown envelope in the bundle. So he'd give me the bundle and he'd put his own views in an envelope and say, "Don't open this until you've come to your views." I used to quite enjoy that. It felt a bit game showy. But yeah, no, it is really helpful, actually, to have your views when we're doing settlement meetings.
I'd probably use a golden envelope, but
of course you would, because you have more flair. Now, I'm conscious of the fact that we've reached the end of our time, but just a couple more slides on questions that we were asked. Do we like to be kept updating? And again, this is a continuum, isn't it? So I've got some solicitors who never update me about anything, including offers made, which is naughty because we ought to know when offers have been made. So every time an offer's made, even if you're not asking for advice about it, just tell us. You should actually be doing that. We ought to be updated on outcomes as well. And actually there's a big bugbear of our fee collector that we don't know when things settle. So, or for example, if something's discontinued, we might be chasing you for fees, and actually it discontinued 2 years ago. The other day I had something that was in the diary for the following week, and the clerks emailed the solicitors say, can we have the brief for Tuesday, please? And they said, oh no, it's settled ages ago. It's like, just tell us, because at the moment it's sitting in my diary, which means I can't do other work. And that's faintly irritating. So not everything, we don't need to be updated about every piece of correspondence, but on major developments, like has it settled? Has there been an offer? I personally like to be updated with expert evidence, but then I don't charge for reading that. If you're going to update us with something that you don't expect to be charged for, then you can send it to us, but just say, this is just for your information. Otherwise you're in danger of getting a bill for it. But I think, yeah, we do like to be kept updated. And actually something that came out from other members of chambers was that they like to be kept updated on whether we've won or not. Because otherwise we'll never know. We'll never know because we won't see it. And it just helps our professional development on a personal level. So yeah, we do like to be kept updated, but not with everything. Now, Peter Hale helpfully asked us what our personal bugbears were. So just on a final note, really, I'm sort of quite conscious of the fact that I sound as if I've got lots of bugbears going through. There's lots of complaining going on. Actually, I don't really have very many bugbears, but just bundles. And I think in particular, the worst thing you can do to me is to send me an email that has a very large number of attachments, and I don't know what I'm supposed to be doing with them. And it takes me half an hour to find the attachment that contains the instructions. Because it's a waste of time. It's just a waste of time. And I don't feel that I've got a handle on the case then for quite a long time. So that's my personal bugbear. Chris is just as bad. You've got bugbears too.
Well, I've got a whole list there, which people thought I was easygoing, but
apparently not. No,
I've mentioned a couple of those. One that I haven't mentioned is, when you ask for a formal written advice and it never materialises, and your counsel thinks that phoning you and giving you the advice over the phone is a substitute for that advice. Setting it out in an email is fine, but I think if you've asked for that, there's probably a reason why. You want that written record to go back to, you want to share it with your lay client. So I do see that from time to time where the written advice doesn't materialise and you're just advised by telephone, and that has its place, but not where you've made a specific request, I think.
Yeah, I think it's just a question of make it clear what you want from us, and then you have a right to expect us to do it, actually. And if someone does do that to you, then you just say, well, thank you, that's been really, really helpful. Can you now put it in a written advice as I asked you?
Yes. Yeah.
But isn't all of this about being assertive?
Yeah, I think there's a big element of that, not deferring to counsel, not feeling that you're subordinate as the instructing solicitor.
Yeah. And I think back in the day, when I first started, there was a big chunk of the bar that felt that all was needed was that they put on a pinstripe suit and then just bullied everyone. And that's the way that we were brought up, 25 years ago. Now, however, barristers are there to help you. We're not there to bully you. That is not or the lay client, even worse. That is not our function. And if you feel that the barrister is not doing what you want them to do, you've got every right to say, you're not doing what I want you to do. And actually, I'm paying you to do this. So could you please do what I want you to do? So those are our bugbears. We've gone over a little bit, for which I can only apologise, but there was quite a lot to cover, as it turned out. I was surprised at how much there was to cover, actually, in relation to this topic. But any questions? Chris, Greetings from south of Carlisle. Everything's south of Carlisle, surely. I'm going to get into such trouble after this. Emma's going to be so cross. Any other questions? Anything that we haven't dealt with? Because there were lots of questions before we went into this, not just on GDPR, which I have to say is Chris's specialist subject, but lots of questions on fees as well. Reduction in fees, who you discuss, who you negotiate with. Lots of questions on bundles I was interested to see. But any other questions from anyone? No, any other bugbears from anyone? I actually think it would be quite helpful for barristers to be told what your bugbears are. Because we don't, when we train, or certainly when I trained, we weren't told how to deal with solicitors. I actually think that would be quite helpful.
Well, the 5 that aren't on holiday at the moment might have attended today, but
sending a draft saying not yet proofread. Why would you do that? I mean, I send drafts sometimes that are going to be changed when, you know, this is my preliminary schedule, but, you know, I'll change it when I get the medical report. I don't think I've ever sent a draft saying, here is a draft that I haven't proofread yet, because that seems a slightly odd thing to do.
Yeah. Well, thank you for having me, Sarah, join you.
Very welcome,
It's
always.
been incredibly enlightening for me.
It has been interesting, hasn't it? I found it very interesting. Now, in 2 weeks' time, I know Emma is going to want me to mention this. In 2 weeks' time, we've got another webinar, which will be me and an as yet unannounced special guest on the topic of your choice, actually. I haven't decided what I'm doing yet, so I'm happy to take suggestions, so do feel free to write in. And I will stop the webinar there. Thanks, Chris. See you soon.
Thanks, Sarah. Bye.